Senator Birdwell,
Present.
Senator Hinojosa, Senator Huffman, Senator Nichols, Representative Hunter,
Here.
Representative Landgraf,
Here.
Representative Menares,
Here.
Representative Sherman, Mr. Babcock.
He's here.
No. Yes.
Sorry, present.
Thank you. Judge Jameson,
Here.
Chief Justice Jefferson,
Here.
Ms. Liberato, Mr. Oliveira,
Present.
Chief Justice Phillips.
Here.
We have a quorum.
Okay, thank you. We have a quorum. Our next item on the agenda is the adoption of the minutes of our October 16, 2020 meeting. They were sent out. I assume everybody's had an opportunity to review them. Do I hear a motion that the minutes of our October 16, 2020 meeting be adopted?
So moved.
All right, it's been moved. Do I hear a second? All right, all those in favor of approving the minutes signify by saying aye.
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 All those opposed, same sign. The motion carries. Okay, I think as we discussed at earlier meetings, we all were very interested in finding out what was going to be the result of our down ballot voting since straight ticket voting had been prohibited by the Texas legislature and signed into law. Well, we now have some data, and we thought it would be very, very helpful to have Dr. Mark Jones, who appeared at our last meeting, to provide us with some useful information to weigh in and kind of really tell us what, in his view, the results are with respect to a system whereby we have no straight ticket voting. So, Dr. Jones, are you here?
Yes, I'm here.
Okay, well, thank you again for agreeing to spend your time before the commission, because the information you have is going to be very, very useful to us. So let me just turn the program over to you, and you can discuss with us the significance of what you found.
Okay. Can I share screen access?
Yes,
I'm sorry?
we're going to give that to you.
Okay, there we go. Okay. Everyone see my present? See the slide, top slide?
Right.
So I'm going to start off, just going to do a real brief overview of the election, just to sort of set the stage, and then we'll go into the judicial quickly, a little more quickly. So statewide level, there was, so these are the results from president down to Court of Criminal Appeals, place 3. And so, there are a couple of trends that we noticed here. I mean, one, that there was a significant gap between Donald Trump and the other Republican candidates. That is, Trump won by 5.8%. And then as you get to the other races, it tended to be in the 9s or to 10, with the principal distinguishing factor was rather in the judicial races, whether there was a libertarian candidate or not. When there was a libertarian candidate, the Republican advantage went down to about 9%, 8.67 on average. When there wasn't a libertarian, the Republican advantage was about 10%. But at the statewide level, the results were pretty similar in terms of there wasn't much of the way of variance across the different judicial candidates. And to the extent to which there was any variance, it was due primarily to the presence or absence of the libertarian, not really due to different vote totals, though we can go into some of the details in a second. So this was the overall result. Statewide, we saw the trend that sort of started in 2018. Here, the dark red is heavily Republican. This is for the Senate race, which we don't have a similar map right now for the judicial races, but the Senate actually, the results are very similar in terms of the partisan composition to the judicial races. And so what you saw is a lot of heavily red rural counties, the urban cores, Harris County, Travis, Dallas, and Bear, blue, and then a pinkening of a lot of the suburban counties. I think that's a trend that started in 2018, and we continue to see this cycle. So, places like Denton and Collin and Brazoria and Williamson County and even Bell County are getting pinker. And then we saw the blue trend that started last time. Hayes County and Fort Bend County sort of retain their blue status. So we saw, in terms of the overall politics in Texas, we saw a deeper reddening of the rural areas and semi-rural areas, places like Tyler and Lubbock, Amarillo. And then we saw a bluing of the urban areas and a pinkening of the suburbs. Now, of course, at the statewide level, the polls made some pretty major errors. That is, if you believe the polls in Texas, you would have thought that Trump would win by about 0.7% if you did an average of them. He ended up winning by about 5.8%. Two polls that did come pretty close were the New York Times Siena poll and the UH Hobby School poll. I helped direct the Hobby School poll. We were pretty close. We predicted Trump would win by 5.3%. Looks like he's going to win by 5.8%. This is just the demographics in Texas in terms of, this is from exit poll data. And this is just reminding us sort of some of the key partisan splits we have, and that Anglos continue to overwhelmingly, and this is for the Senate race, and this is the closest we can get to judicial because there isn't a poll on exit poll on the judicial races, but the Senate race, its partisan distribution is very similar. So in terms of overall support, the Republican support was 68%. Among Anglos for Cornyn, 30% for Hager. Latinos split 56% for Hager, so we can say that's 56 Democratic, 42% for Cornyn. The African American vote, as traditionally the case, was about a 90-10 in favor of Democrats, and then the Asian American vote was 60-39 for Democrats versus Republicans. So overall, sort of the trends that we've seen in recent elections continue this time around. That is, Texas Republicans win an overwhelming share of the Anglo vote and win a decent share of the Latino vote. And that's really the secret to the continued Republican majorities, those two factors working in tandem. Statewide, though, what we have seen is during the Trump era, a couple of things happened, and that is, while Republicans remain the majority party in the state and continued the statewide winning streak, which I believe is now 153 straight elections dating back to 1996, the margins have dropped a little bit, particularly if we compare it to earlier in the decade. So for the Supreme Court of Texas, you can see the margin in 2012 was 12% on average of the competitive races. It jumped to 23 in 2014. Was 16 in 2016, but the past two elections, it was 7% and then 9%. 7% in 2018, 9% in 2020. In the Court of Criminal Appeals, was 14, then 23, then 14, then 8 and 10. That difference is explained almost exclusively by the lack of libertarians. As I've mentioned before, the libertarians cost Republicans statewide about 1% of their vote margin. So, and just as we saw the Republican sort of majority decline, we also saw something similar occur in the Texas House, the Texas Senate, and the U.S. House delegation, which prior to Trump's arrival were at 98, 20, and 25. In the first Trump election, 95, 20, and 25. Then 2018 fell to 83 House seats, 19 Senate seats, 23 U.S. House seats, and then sort of stayed the course for 2020, just losing Senate District 19, which was more or less gifted to them in a special election by Bexar County Democrats in a way. But that seat came back, and so now a lot of Republicans are treating this election with relief. That is, that things didn't get worse for 2018. At the same time, though, it is much worse than 2016. So it's sort of a glass half full, glass half empty for both Democrats and Republicans. If you're a Democrat and your base of comparison is 2016, things are much better. If you're a Republican, if you're a Democrat and your basic comparison is 2018, things didn't get better. In fact, they probably got at least a little worse, or at least stayed constant. One final thing, and this I just want to point out, one change that occurred during the Trump era is, while we saw differences in the sort of the loss of seats, we also saw something on the Democratic side, which was, and we saw this across the board. I'm just using the U.S. House here as an example. We saw far more competitive candidates and far more competitive campaigns than was the case in 2016 or 2014. So if you think back to 2014, or let's say even 2016, 25 Republicans won in their U.S. House seats. 18 of them won by 20% of the vote or more. Only one of them, Will Hurd, faced anybody who raised over $100,000. and 24 of them won by 10% or more. Fast forward to 2020, 2 seats have been lost. Only 11 won by 20% or more. 15 faced a candidate who raised 100,000 or more, and perhaps most importantly, 9 faced a candidate who raised more than $1 million. So Democrats during this time period also began to run higher quality candidates and better funded candidates. So now to the judicial election. So first, sort of looking at the courts of appeals, and I think the relevant ones here, for our discussion, are really focused in on the 1 in 14 and 13. So here's where, this is the appeals court results. Once again, we had sweeps in all of the appeals courts. So that was something that we were interested in seeing with the end of straight ticket. Would you start to see the decline of sweeps? Now, on one hand, within the appeals districts, we didn't see a difference in sweeps. Of course, since 1 in 14 overlap, we did see a difference there. That is, for whatever reason, 1 is primarily due to candidate strength, that was success or something related to the candidates. 1 is went slightly Democratic, whereas 14 went slightly Republican. So that is a difference compared to what we've seen in the past, but not dramatically so. Okay, we also, so we saw some competitive races this time around. And so there were, within the districts, we did see some more greater competition, but the competition tended to tilt one way or the other. 2 of the races are still probably too close to call. I'd say particularly this race up here, the first place for place 5, with the difference of only 1,367 votes. We'll have to see for the final canvassing. I mean, odds are Getter will still win, but that's a small enough margin out of 2.3 million casts that you need to wait for the final recount. So we also saw judicial sweeps again. So in the appeals court districts, all of the counties had sweeps again. So compared to 2016 and 2018, there weren't any we had the same level of sweeps. So in that sense, getting rid of straight ticket voting didn't change anything. We had 1 county level race in Nueces where there wasn't a sweep, but everything else was a sweep. So, theoretically, you would think that getting rid of straight ticket voting should decrease the number of sweeps, but we still had them. We also, this was a measure of looking at sort of the differences between the candidates. And the idea here is that what's the difference between the candidates that are in different pairs in different districts. So statewide, you have candidates that are competing in the same space. So say, for instance, the 3 Supreme Court candidates that have libertarians competing against them, or the 3 Court of Criminal Appeals candidates and 1 Supreme Court candidate who was just Democrats and Republicans. What's the difference between the amount of votes won by the winning candidate? And so you can do that at the appeals court levels and then within the 20 largest counties. And you get these pairs, that is pairs of candidates, and you can look and see how different are their vote results. So what we would expect is that moving from getting rid of straight ticket voting would lead to greater differences, because the idea of straight ticket voting was that you had lots of people that were voting, all were voting straight Republican or straight Democrat, and that translated all the way down their ballots. So it guaranteed that the candidates would get very similar results. Once you move to getting rid of straight ticket voting, you would expect to see more variance as people went down the ballot, that they might use candidate quality to actually sort of determine who would be elected. The results, though, the data don't support that at all, though. The data actually support that the results were closer. That is, that getting rid of straight ticket voting, if anything, caused the proportions of the vote won by the different candidates competing in the same jurisdiction in different races to win similar amounts of the vote. So the average difference in 2016 statewide was 0.56. The average difference in 2020 dropped to 0.41. It's smaller, not dramatically, but it is smaller. The range is also sort of a little more shrunken. For appeals courts, it was the median difference was 1.04% in 2016. This time around, it was by half, although we have such a small number of cases that you really don't want to read too much into that, but it's in that direction. The place where we have the best evidence is really the county level, because there we have enough pairs. These are the 20 largest counties looking at all of the pairs of candidates who so like in Harris County, we had 15 competitive county level races. So that leads to pairs of all of those different candidates, all of them with each other. We also had, so we had 186 pairs across the state of Texas this time around. Back in 2016, we had 180. In 2016, the median difference between those pairs was 1.0%. This time around in 2020, it was 0.74%. So based on these data, the conclusion would be that people actually voted more straight ticket without straight ticket than with the straight ticket. That is, people going down the ballot voting all Republican or all Democrat, doing it manually, created less difference between a party's candidates than there had been when we actually had straight ticket voting. So I mean, one way to think about it is, if the question is, did straight ticket voting result in more variance across the judicial candidates? The answer is no. If anything, it resulted in less variance across the candidates. There's also the issue of roll-off. Okay, roll-off is when people who voted in one race don't vote in the subsequent down ballot races. So we can use as the base of comparison here the presidential election. And so if this is the total amount cast, this is prior to the final canvass, 11,231,799 votes cast in the presidential race. And then the following numbers here are just simply the proportion of the people who cast a vote in the presidential race who also cast a vote in the railroad commissioner race. And the number here to the right is what the case was in 2016. Here, these aren't obviously the same places for the Supreme Court or Court of Criminal Appeals. I've just added them in the order in which they were on the ballot. From the court races, I think the one thing that stands out here is that roll-off was slightly higher this time around, but relatively marginally so. At most about, on average about, half, but 3/4 to 1% less. So in this case, at the statewide level, we did have more roll-off than 2016, but it was pretty modest. That at about maybe one, if we think it's sort of between 0.75% and 1%, it's right around there. I would say closer to 0.75% if we averaged it. So really, so you had people not voting in these races, but it was very minimal compared to what had been the case with straight ticket. And so one of the things we thought straight ticket might do is lead to lots of people walking in and simply not voting after the first few races. That really didn't occur. You can see even in the first drop off, when this is one of the biggest ones between the president and Senate is about about 165,000 people out of 11 million maybe didn't make that next. Now it's ecological, so we don't know exactly, but we can sort of assume that we're getting that type of drop off. So there really wasn't that much of a drop off due to the lack of straight ticket voting compared to 2016. It's present about 0.75%, but it's not very large, and at least at the statewide level. So also can look at sort of Harris County as sort of a case study, because if we're going to see an effect of getting rid of straight ticket voting, Harris County is going to be probably one of the places it's going to show up first, simply because it's such a large county and it has so many county level races compared to other counties. So what we found is really, there really wasn't that much of a difference. So one way to think about it is the gap between the 25 percentile and 35 percentile. The gap was only slightly larger in 2020. That's statistically not significant. And the highest gap was 3.18 in 2016. It was 2.96 in 2020. So once again, the conclusion we make here about Harris County is, at least in terms of variance across candidates, we didn't see any real change compared to straight ticket voting. That is, you had a pretty similar difference among the candidates. And so, which you wouldn't have necessarily expected. Straight ticket voting, we might have thought that it would have led to more variance as people went down the ballot. They might have freelanced across different candidates or different parties. That didn't occur. So once again, no real effect from straight ticket voting. And this is just looking at roll-off in 2016 compared to 2020, just in Harris County. So where we have one of the longest ballots. Once again, it reinforces somewhat of what we saw at the statewide level, in that roll-off existed. So by about 0.5 point for the Supreme Court Court of Criminal Appeals, The differences for the appeals courts were not really noticeable. And then when we got to the county level races, roll off back in 2016 for the first half of the races. That's just, I just divided them, the ones that came to the first group and then the second group, just as people get moved down the ballot, there tends to be more fatigue and a greater likelihood people aren't going to vote. We saw that, but that occurred in both elections. And so, probably the only place where we start to see some noticeable is at the very bottom part of the ballot this year. You saw more fatigue set in, especially in Harris County where you're voting on a computer. When people started hitting the page after page, when they got to those last pages, a small group of them began to not vote. So roll-off did occur in Harris County. But once again, it's similar to what we saw at the statewide level. It's modest, although it did. I think we can say that while I think one conclusion we can make regarding the getting rid of straight ticket voting is that while there was no real difference on the share of the parts of the vote won by different candidates of the same party competing in the same district. So it didn't lead to greater variance in the votes received by a party's candidates. It did lead to a very slight increase in roll-off, both at the state level and then in Harris County. Okay, so that's the rest I had just was something on the legislature, but judicial, I think that's the main points. Then I don't want to run over time, so I'll stop here. But if anybody has any questions about the legislative races, I'd be happy to discuss those.
Dr. Jones, this is David Beck. I guess I assume what you're telling us basically is that there hadn't been much change, even though there was no straight ticket voting, at least in the big metropolitan areas like Harris County. There really has not been much change. And my question to you is, do you have any sense of why that is? Were people just educated about slates of candidates? But what do you attribute this to? Do you have any thoughts at all on that point?
I mean, I think if anything, I think it's just we were in a very partisan election. And so I think people got the message that they needed to vote partisan. And so most people replicated the straight ticket themselves. So instead of going in and hitting the straight ticket, they simply went down the ballot voting Democrat, 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 all the way down, or Republican, Republican. So they replicated it, which one thing that may have aided that is COVID-19, in that because of COVID-19, I said two things. One, COVID-19, and then here in Harris County, at least, we had a new person running elections, Chris Holland. So COVID-19 led to extended early voting. So people were less rushed, waiting in shorter lines. And so it may be that when they got into the polling place, they were more willing to spend the 10 minutes or 15 minutes in Harris County that it took to go all the way down the ballot. Whereas we could envision that in another election where lines are longer and people are more short-tempered or have been waiting, they may be more rushed and may not be willing to do that. That'd be one option. Also, at least in Harris County dramatically expanded the number of early voting sites and pretty notably increased the hours, which meant shorter lines as well, and therefore more time for people to go through the whole process. But yeah, what was pretty remarkable about it is that from a partisan perspective, there was almost no variance. Now, we did see partisan variation in the state house level, but that's because of information. That is, most voters have very limited to no information about the judicial candidates, so they tend to vote based on partisanship. And we had several competitive state house races. A great example would be Morgan Meyer up in Dallas, who I think outperformed the baseline Republican vote by about 8 or 9 points. But I also think he spent close to $2 million to get that support.
Thank you. Very helpful. All right. Any other questions by members of the commission?
I do.
Okay. Yes, sir. Representative Hunter.
Yeah, I want to tell you, Mark, you probably don't ever get complimented, but you were accurate in South Texas. And to me, that's important because that's rare. And so you did, but I would like to hear your legislative analysis, because to me, that impacts judicial as well.
Okay, let me, I guess, pull that back up. I'll go through it real quick. Okay. Can you all see the House Democratic targets? Is that showing up?
Yes.
Okay, sorry. Okay, so I think with the House races, what we saw was, Democrats targeted. These are sort of the 12 or 13 top targets that Democrats had, and most of these are races where Beto O'Rourke, if he didn't win the district, came very close, and back in 2018, Democrats came very close. I think of these, though, only one flipped. That was Sarah Davis here in Harris County, and 134, where Ann Johnson defeated her. And that was in large part, that was a district that is now dark blue, that Sarah Davis had been winning in spite of the fact that she had an R next to her name. And this time around, it was just, she wasn't able to survive. But across all the other districts, Republicans held their own, I think in part because this time around, unlike the case in 2018, Republicans were ready for a competitive race. And so most of these candidates were extremely well funded. And we're also campaigning from the very start. And in some cases, I think the statewide GOP worked well and recruited some really good candidates. I'd say J.C. Jatan up in Fort Bend County and Lacey Hull and Harris. I suspect if some of the other candidates who had potentially been running for those seats had run instead of Jatan or Hull, that those seats might have flipped. And likewise, I think if Democrats had run, if Suleiman Lalani had won the Democratic primary, that would have been more competitive. So this was sort of the overall, I think, on the Republican side, the targets, and Republicans played really good defense. On the other hand, Democrats played pretty good defense as well in terms of holding on to all but one of the gains that they had in 2018. That is only the only loss was Gina Kalani, who had barely won 132. And that was in part because I just don't think in 2018, that's a good example of somebody who was caught unawares. Mike Schofield had not really campaigned very hard back in 2018. But Democrats were able to also hold on to all of their seats. And there were some of the seats that they won back in 2018 that weren't even all that competitive. So they weren't even on this list. So these are 9 of the 12 that they won last time around. But in a lot of the races, the gap was larger. Particularly, John Turner did really well. Retta Bowers did pretty well. Ana Maria Ramos did well. So these are races that the Democrats, I think, did a good job on defense. So in a lot of ways, this was sort of cementing in the status quo. So this is like why you can look at this election as glass half full, glass half empty from either side from either party. In that, from a Republican perspective, the positive was that you were challenged in 13 districts and you held all but one of them, and then you took back one district. From the Democratic perspective, you held all but one of the districts that you won back in 2018, which was 12 better than you had back in 2016. But overall, I think in these races, this is where I think one place where, if we were talking about the end of straight ticket voting, where straight ticket voting, I think, was beneficial to Republicans was in these races here, because we're still looking at the data, but we saw Donald Trump lost a lot of these districts. One of the reasons why we don't see much variation in the judicial races is the campaigns don't spend a lot of money and develop so there's not much of a personal vote for the individual candidates because voters don't have much information, therefore they vote mostly based on partisanship. These state house races are an example, though, particularly several of these Republicans who did significantly better than Donald Trump, is that when you are able to create that personal vote, which generally is a combination of incumbency, which helps, and then also simply spending the money to create that positive image, the end of the straight ticket voting gives you more flexibility to do that. So if you're a stronger candidate, even if you're in a district that is going against your party, you're able to survive. Angie Chen Button's a good example of that. She's surviving narrowly, but both she and Morgan Meyer substantially outperformed Trump in their district, as did Sarah Davis. It's just, I mean, I think Trump lost that by 24, 25%. So she's, she came close, but wasn't able to close the gap.
Any other questions of Dr. Jones? If not, Dr. Jones, thank you so very much for coming back a second time and subject yourself to questioning by members of our commission. This has been very, very educational and very helpful. And thank you again for sharing your data with us. We really appreciate it.
Lynn, can I ask a quick question?
Sure.
Jones. Dr. Jones, I understand that Supreme Court Justice Jane Bland got more votes than anybody in the state.
Yeah.
Why do you think, obviously she's a quality candidate, but I suspect there's more to it than that. Do you have thoughts on why a Supreme Court Justice, in particular Justice Bland, had such an overwhelming vote?
The principal reason is that there was no libertarian on her ballot. So she was one way to think about it is she was in the highest position on the ballot where it was only a Democrat and a Republican competing. So that's one factor. So unlike Railroad Commission, which had a Green Party candidate, and Railroad, Senate and President had both Libertarian and Green, and then the other Supreme Court races had a Libertarian. She did not. So that's one. So, and she's higher up than the Court of Criminal Appeals, which would be the next highest races that didn't have a Libertarian. And then there's a little evidence when Republicans run women as candidates, they get a boost. And when it's a Latina, they get an even bigger boost. It's a margin, it's a modest, and it's in low information elections. The higher the information, the less important the effect. But there's a pretty notable effect, and you can see it just looking at county races. Almost always, unless there's a strong incumbency advantage, if Republicans run a Latina, she's generally going to edge out all other Republican candidates at the margins in the district. And then if it's a woman, is going to generally outperform a man. All things being equal about candidate quality, et cetera. But in low information races, Republican women tend to do a little better than men. So that would be but it's mostly no Libertarian, high up on the ballot, and a woman.
Thank you.
All right, any other questions? If not, thank you, Dr. Jones. We really appreciate your appearance.
Thank you. And anybody, feel free, if anybody has questions, feel free to contact me. Just if you Google Mark Jones Rice, I'll pop right up. So feel free to get in touch.
Thank you very much.
Thank you.
All right, our next presenter is Ross Fisher, who's a former chair of the Texas Ethics Commission, who's going to talk to us on the subject of judicial campaign finance, a subject near and dear to Charles Babcock's heart.
Thanks, Mr. Chairman. Can everybody hear me okay?
We can, thank you.
Okay, great. I'm going to work from some prepared remarks, and I think that Megan might have a PowerPoint that she can share with the commission. So
Yes, we're going to share that. And we're getting a little bit of feedback from your microphone too. I don't know if there's.
Is that any better?
It's a little better. It's like a little ticking.
Sorry. I found that it works better with the microphone than without. Is that okay?
Still getting, but maybe it will go away. We're still getting a little bit. Okay, we're going to share those slides. Just a second. Here we go.
Okay. Can you hear me okay, or should I try a different? Should I unplug this microphone and try a different approach?
You might want to try, because I think it might be a little bit distracting. We're getting a lot of feedback with it.
Well, I think all the commissioners ought to go on mute during the presentation.
Yes.
Is that better?
That's much better.
Okay. Good. If that's better, then we'll do it this way. You can hear me okay?
Yes.
Great. Okay. Well, let me pull up my remarks and I'll go through those, and feel free to interrupt me as I'm going through them. And I'll kind of give you a cue, Megan, as we get to different slides, if that's okay.
Okay.
Yeah, so thank you for the opportunity to join you and for the work that each of you has put into this important endeavor on the commission. As the chairman mentioned, I used to serve on the Texas Ethics Commission. I was a commissioner for 5 years. I was appointed by Governor Rick Perry. I served as the commission's chairman in 2009. And in my role as a commissioner, I developed an intricate understanding of the judicial campaign finance system. My departure from the commission coincided generally with the U.S. Supreme Court's decision in Citizens United. And so I've spent the last decade working in the evolving field of post-Citizens United campaign finance and issue advocacy. So it's with that experience in mind that I want to identify some trends that I've seen in the last 10 years that are likely to impact the scope of this commission's work. I mean, and as those of you, I know we have a lot of former judges on here, you know that our campaign finance system at its most fundamental is really designed to illuminate money entering and leaving candidate campaigns. However, in the last 10 years, the law has had to adapt to address independent expenditures made by third parties, and that's what I want to focus on mostly today. Each of these facets has a growing impact and a direct impact on elected judicial officers. And my current concern is that these political pressures that are exerted on our judiciary won't stop on election day, but will be used as a means to influence judicial decision-making in real time. So I want to draw your attention to that today. I want to talk a little bit about contributions and expenditure, candidate contributions and expenditure. I mean, it comes as no surprise to those on this commission that those most involved in financing judicial campaigns are lawyers and their clients, right? In other words, the very people that are likely to appear before elected judges, either as advocates or as litigants. Public records show that in the most recent election cycle, over 40% of political contributions to judicial candidates came from attorneys or law firms. So that's nothing new, but I think it's important to note, right, that the largest funders of elected judicial campaigns and candidates are lawyers for those judges. And I do think it's worth noting that judges of criminal courts are at a further disadvantage because their jurisdiction doesn't lend itself to muddied interests, but to more fundamental freedoms. And I think educating the electorate about criminal courts is an expensive undertaking, but scant resources are available. And as a result, and I think you heard this in your last presentation, voters are likely to make choices on other factors, including party affiliation or name identification. So that's the state of play with regard to contributions, is that judicial races are funded primarily, the largest employment sector, occupation sector is lawyers, is the legal field. So next I want to talk about candidate expenditures. Judges facing elections, they have to raise funds in order to communicate with the electorate. However, as previously noted, those funds are likely to come from contributors who will be seeking a judge's favor in court. On the whole, the limited contributions make it more difficult for judicial candidates to communicate with the electorate. And so these issues, contributions from lawyers and difficulty of educating voters about down ballot races, are really nothing new. But what's relatively new, and if you can go to slide 2, would be great. Yeah, or you can go back one. Thanks. Yeah, so what's new, or the relatively new, is the development that's predictive of problems facing independent and impartial judiciary, and that's the rise of independent or direct expenditures. People refer to them as independent expenditures. Is more of a federal term. In Texas, they're known as the term of art is a direct expenditure, but we use them interchangeably. Direct expenditures allow interested parties, whether they're lawyers, litigants, corporations, labor unions, to circumvent the contribution limits, provided that they also circumvent the candidates, right? They're allowed to make uncoordinated direct expenditures in the post-Citizens United universe. So as long as they're not coordinating with candidates, they can spend unlimited amount of money to influence elections, provided that that's disclosed, right? So as a result, and this is for all races, but in particular for judicial races, the candidates become peripheral to their candidacy as third parties craft messages, spend money, and influence voters. So a motivated third party will have more sway with the voters than the candidates themselves. Stated simply, direct expenditures allow for more money in judicial races than the law envisions, subjecting judicial candidates and office holders to greater outside influences. You can go to the next slide, please. So just as an example, in August of 2020, there was a Texas hybrid PAC that was formed, and that's a kind of PAC that allows you to make contributions with non-corporate money and direct expenditures with corporate money. So this PAC was formed in August 2020, and in the 8-day report for the week preceding the November 3rd, 2020 election, they reported spending $4.3 million in direct expenditures on behalf of the Texas Supreme Court candidates, the incumbent candidates, during the final days of the campaign. That's all reported, it's disclosed. You can pull it up on the Ethics Commission's website. If you pull up the same report, the reports for the same time period, the 8-day pre-election reports for those candidates that were benefited, they spent $1.2 million, roughly, communicating with Texas voters. So what it means is in the final days of the campaign, the direct expenditures supporting certain candidates were triple the amount of what those candidates spent themselves. So this is all within the bounds of the laws that currently exist. But it's predictive of future judicial elections that third parties will exercise their right to free speech in order to influence voters. We go to the next slide, please. Thanks. So this is my real concern, and this is what I want to draw your attention to today, are what I'm calling off-season direct expenditures or issue advocacy expenditures. So as direct expenditures are increasingly used to influence judicial elections, it's not difficult to see how those same expenditures, those same strategies under the guise of issue advocacy will ultimately be used to influence judicial decisions. Just as direct expenditures can influence who voters support, those same types of expenditures can be used to draw voter attention to pending cases, casting judicial decisions in political terms, and potentially injecting politics in what should be a legal decision. So, and as so long as a communication avoids mentioning an election, issue advocacy of that nature is wholly outside the realm of our campaign finance laws. Therefore, it imposes no prohibitions on the source of the spending, and no disclosure requirements. So consequently, a third party, whoever it is, a litigant, a special interest group, anybody, that has the resources and is willing to spend them, a third party can spend money to assert public pressure on judges during the midst of a trial, in the midst of any pending case, without ever having to disclose the activity or its sources, because it's not election related. And because it's not election related, it's mere issue advocacy, it doesn't fall within Title 15 of the Election Code. So independent and direct expenditures can also become the basis of judicial recusals, forcing judges to remove themselves from a proceeding for conduct, not their own conduct, but for the conduct of a third party. So I'm sure most of you are familiar with the 2009 U.S. Supreme Court case of Caperton v. Massey Coal Company. In that case, the president of a coal company was appealing a verdict and spent $3 million to elect a new judge to the West Virginia Supreme Court of Appeals. He contributed so they have limitations on how much you can contribute to a judicial candidate, and they're much lower than Texas, right? It's $1,000. He contributed $1,000 to the candidate he was supporting. And then he also contributed $2.5 million to a PAC, a Federal 527, a political committee that was called For the Sake of the Kids, and that supported his chosen candidate. And then he made $500,000 in independent expenditures, so direct expenditures to communicate with voters on behalf of his chosen candidate. When the case, so his candidate was elected, and when the case, the litigant, the other opposing party said, we want that person, the new justice, recused because they can't be fair and impartial, because they were essentially funded to the tune of $3 million by this party, the president of the coal company. Went all the way to the U.S. Supreme Court, and the U.S. Supreme Court ruled that campaign-related expenditures in this case were so significant that they required the justice's recusal under the Due Process Clause, finding that the probability of actual bias was too high to be constitutionally tolerable. And so this was decided before Citizens United opened the floodgate to direct corporate expenditures in our election. And interestingly, Caperton's not it's not a campaign finance case. It's not a First Amendment case. It's a due process case, basically saying, is the due process of this party to litigation affected? And they said that independent expenditures made by a party in court can force the judge into a recusal situation. So that's, in my opinion, that's not fair. It's not fair to the parties. It's not fair to the judge that they might be forced into a recusal situation by conduct that's not their own. That's a third party. And I guess the other key thing I want to focus on is really not fair for the public, right? My prediction is that unlimited, undisclosed, so-called issue advocacy will be used not only to influence elections, but will increasingly be used to influence judicial decisions in real time. And as long as judges remain subject to political whims of special interest and to the general electorate, the sophisticated influence campaigns that you're seeing around election time, they're going to continue, and you're going to see them more and more in the off season. Instead of trying to affect elections, affect cases. I think my opinion is that this is a disservice to the judges that are on the bench, to the litigants that are in the courtroom, and to the public at large, right? Judges are supposed to be impartial arbiters, and should not be subjected to a barrage of outside influences intent on swaying legal decisions. Litigants shouldn't have to worry about whether their legal interests in the courtroom are outweighed by political machinations outside the courthouse. And the public should have confidence in the judiciary is impartial, that its decisions are based on the law, and that those participating in the justice system can expect substantive due process. We've seen recent studies that have indicated a concerning level of public skepticism about the fairness of the judicial process, both the criminal justice process and the civil justice process. There's even higher numbers of Americans that question the legitimacy of our electoral process. And so it's only natural that a system of judicial elections will invite even more cynicism from the public. And this waning confidence in our governmental systems underscores the need to protect our judicial system from outside political forces. For the public to have confidence in the justice system, there must be a shared belief that the system is fair, impartial, and substantively reliable. The more that judges are subject to outside political forces, the more strained the faith in the system will be. That concludes my remarks, but I think the takeaway here is that these sophisticated independent expenditures that you're seeing during election season are going to provide the groundwork for similar campaigns during the off season. So it's really, to my mind, there's problems with the judicial campaign finance system, but post Citizens United, this is moving beyond a campaign finance problem into a real problem, a broader problem on the independence of the judiciary. So I appreciate your listening to my remarks. Megan, thanks for going through those slides. Yeah, can you go to the last slide? Is that it?
This is the last slide.
Okay, great. Yeah, this is sort of highlights what I think are the issues that lay ahead of us. So I'm happy to answer questions.
You're muted, David.
Thank you for appearing before us. May we have a copy of your slides to use for future reference?
Absolutely.
Okay. Let me open it up to questions. Chip, I'm sure you've got a question there somewhere. So you want to fire away?
Yeah, I have several. Thank you, Mr. Fisher. My first is, it is almost a rote statement by judges that they don't care who they get their money from, how it comes to them, or how much. It's not going to influence their judgment or opinions. Every judge will tell you that. It may be true, it may not be true. But do you have an opinion about what all of this money flowing into our judicial races does to public confidence in our civil and criminal judicial system?
Sure. I think that that's the real issue, right? I agree that every judge is going to say that they're not influenced by campaign contributions. I'm willing to give them the benefit of the doubt until proven otherwise. But I think that from a public confidence perspective, when the public sees, first of all, you got waning confidence in the electoral process generally, broadly, and then to an extent, skepticism about the fairness of the court systems. So I think that when people see those ads, when voters see the amounts of money that are spent to influence judicial races, it will erode public confidence. It's already being eroded, candidly, but I think it'll further erode public confidence in the independence of the system.
Okay, follow-up question, if I may, and that is you raised the issue of the issue advocacy, and I suppose that is done, frankly, when litigants are trying to get the Supreme Court's attention. There are ads that are run, et cetera. U.S. Supreme Court, I'm talking about. How would you propose that we recommend that be fixed? From a First Amendment perspective, of course, you can't keep people from advocating whatever they want to advocate. But if you're elected or if you're appointed, how are you going to fix it? In other words, what is your recommendation for what we should recommend as a fix to the problem with the money in the judicial system?
Well, as you noted, you can't limit the expenditures, right? It's free speech now to spend money for whether it's individual, a PAC, a corporation, a labor union. So that's not going to fly, right? So I think that the fix has to be on how judges are selected, appointed. You have to inoculate the members of the judiciary from political influence as much as you possibly can. So I think it means I think that elections are going to remain problematic. Let me say that broadly. Nonpartisan elections still going to be problematic because of the free speech rights of all these entities that are involved in judicial elections. So I think nonpartisan elections, that's not going to change that. Even retention elections, there's a case in Iowa where they had judges appointed and then they all got, it was a coordinated effort to remove them in a retention election, which was successful. So I think any judicial election is going to open itself up to issue advocacy or issue advocacy in the off season, and then campaign advocacy or election advocacy during the campaign season. That's the other thing, is that our judicial finance system in Texas, at least, is set up on this theory that you only campaign or politic during a very limited time of your term, right? There's times when you can raise money, most of the time you can't raise money, the time when you can spend money. And so it envisions the judges limiting their political behavior, their political conduct to election season. And that's just not feasible these days, right? You'll have to issue advocacy going year round. So I think that any kind of election at this point is going to subject judges to political pressures from third parties.
Okay. One final question on a slightly different issue. From your perspective as chair and member of the Ethics Commission, how are these judges spending their money? I know there was a judge in Harris County who had no opponent in this election and yet was very aggressive in raising money. I've heard that some of the judges contribute to parties or to other entities. How's the money being spent?
Mostly it's being spent on voter communications, like direct mail or direct mail, email, political consultants who are reaching out to voters. There are limitations on how much judges can give to other parties and to other candidates. There's a little more freedom now, I think, to support political parties than there used to be. But for the most part, it's voter outreach.
Yeah, thank you very much. Thank you, Chairman Beck. Sorry to dominate the questions.
No, that's all right. I know that's a subject near and dear to your heart.
It is.
Any other questions by any members of the commission?
Yes, Mr. Chairman, I have one.
Okay.
Thank you,
Chief.
Mr. Fisher, for that was an excellent presentation. On the area of issue advocacy, I can see where that could be a very big problem, but do you have any examples or evidence of expenditures in specific cases outside the electoral process that you can point to, or is this just looking in the future about how much this could be used to influence or attempt to influence what a judge does.
It's more I don't have any Texas specific examples. I think that this is more looking into the future. I think you'd have to find the right circumstance, a pending case with a well-heeled party who is willing to spend the money. So no, it's more predictive. I don't have a good example, but I just having been around this system for a while, it's real easy to see how you could have an issue campaign that says, call the courthouse and tell Judge Fisher to support XYZ or to prove himself a friend of strong families in this case, right? And that would exposure to that. It would all be hidden from public view. So I don't think it's happened yet, to my knowledge, but I think it's easy to see coming.
Thank you. I can see it as well. Thanks.
Chairman Beck?
Yes, is there another question there?
Yes, thank you, Mr. Fisher. I am understanding that your fix would be in how to nominate judges rather than elect them. I didn't hear a fix that would be limited to campaign finance limits in Texas. Is that correct?
Right. You're right. I didn't address that. I mean, so I guess let me understand your question. Right now, the problem, I think, is that there's limitations. I don't know if this is a problem, right? There are limits on how much people can contribute to judicial candidates. I don't see that as a problem in and of itself, right? I don't think the answer is to just take off the limits and let people contribute more to judges. That's not the answer. But because you can limit campaign contributions because of the perception of quid pro quo or corruption. The problem since Citizens United is the rise of these independent expenditures. And so people who are motivated to influence judicial elections know their money's not going to go very far in contributions.
Yeah, right. Not to interrupt you, but you're not saying that the voluntary limits that we have today should be further reduced.
I'm not saying that.
Okay. And the other thing you mentioned was in the selection process, you would inoculate the judges against outside influence or alert them to the dangers. What were you thinking about that? What would the nominations commission say or do with the proposed candidate?
No, I guess what I was saying is that once they're on the bench, that they ought to be inoculated, whether they're appointed, they ought to be inoculated from political considerations when they should be making legal decisions, right? And they shouldn't be, they should be inoculated from political considerations to the extent that they can. And so I think that if you have some other, I'm not here to recommend a certain outcome or certain solution today, but I think that as long as you have some election, you're going to have some variation on the same issues that we're seeing today.
All right, thank you.
Mr. Fisher, I've got a question. This is David Beck. Should the commission decide to recommend an appointive system with a retention election by the judge, don't you still have the money issue arise when the judge is running a retention type election? It may be significantly less, but don't you still have the same issues?
Yes, I think so. And that's what happened in Iowa, was that there was an appointed 3 judges that had been appointed that were up for a retention election, and there was just a well-coordinated political campaign that ousted them on what I would call policy reasons and not legal reasons. So I think you still have those issues.
Okay, thank you very much. Any other questions by any member of the commission? If not, thank you very, very much for appearing before us and taking your time. This has been very, very helpful to us.
Sorry, I had a question. I'm sorry.
I'm sorry, I didn't see that. Another question?
Yeah, I couldn't unmute fast enough. Sorry. Mr. Fisher, I have a question. I'm curious about, yes, this in the retention election where they all lost. Was that, it was a political issue? I just want to expound on that a little. It wasn't policy, it was purely political, you believe?
Yeah, I think it had to do with same-sex marriages was the overriding issue that led to their removal.
And so was it a well-funded type of election and organized by someone who had different political views than I assume the judges did?
I don't know. I have found some literature on it. I'm happy to share with you or the committee.
Okay. Yeah, I'm just trying to expand on this, that even when you go to the retention or the appointment system, is still, and I think other people who have testified, experts testified to us during this process, have continued to point out that it still doesn't take the politics out of it.
I think that's absolutely true. I mean, I think, right. I think the retention elections are subject to the same political machinations that a regular election.
Sometimes we've been told that retention elections tend to be just based on that it's pretty hard to lose a retention election in many cases. I've been told maybe that's wrong. I think that's what a lot of people believe. But it's interesting that you're pointing out that all three of them lost. So certainly it can be. I think that's right. Yeah, it can be. If there's a concerted effort to get someone or a group of individuals off the bench because of certain political beliefs, that if I guess enough money is spent, again, back to the money, that maybe that can be accomplished. Thank you. Thanks for your participation today. Thank you. Thank you, Mr. Chairman.
Okay, Chief Justice Jefferson, did you have a question?
I was just going to say that I've spoken to the former Chief Justice in Iowa, and she said that although the campaign was about same-sex marriage that ousted those incumbent judges in the retention election, that the funding was more of a tort, business versus plaintiffs issue, and that the business community was dissatisfied with their rulings in tort cases. And so that just shows you that you can highlight a social issue that that gets the public engaged, but the ulterior motive is not on the social issue, but on subsidiary issues.
All right, any other questions of Mr. Fisher? If not, thank you very much, Mr. Fisher. We appreciate your appearance today.
Thank you for having me. I appreciate it.
Okay, we've reached the point in our agenda under number 5, new matters, which is to discuss the draft report and recommendations. And let me say that I am not going to call for a vote on anything today, but I do want to open discussion about the subjects that the legislature has mandated that we address. And so I'd like to have an open, full, and frank discussion of some of these issues that were presented by the people who have appeared before us. In my view, at least, there are 2 cardinal principles that directly affect our judicial system and its integrity. First of all, it's the independence of the judiciary. It is critical that our judiciary be totally and completely independent. If it's not, I think, as some of our speakers and presenters have said, people lose faith in the judicial system. The second cardinal principle, in my view, is the rule of law. One of the concepts that differentiates us from other countries, particularly dictatorships, is the rule of law. And so we must, in our system, embrace the rule of law as well as the independence of the judiciary. In my view, those are the 2 cardinal principles that we have to be mindful of and address. If the people lose faith in the integrity of our judicial system, then at least in my view, our system cannot and will not stand. So I think that the mission before us is very, very important. And so to me, the fundamental issue that we have before us is what can we do, if anything, to improve our current method of selecting judges? And I'm going to say that again. What can we do, if anything, to improve our current system and the way we select our judges? We have heard people say, don't do anything. We've had judges and former judges appear before us. Some say change the system. Some say don't change the system at all. We've had people say improve the qualifications of our judicial candidates. We've heard people say get money out of the system. We've had people say, change the system entirely, go to an appointive system. And that's why I sent around this menu, if you will, of various subjects that have been raised by the presenters who've appeared before us. So I'd really like to open it up to discussion and just have people address this fundamental question of what can we do, if anything, to improve our current system. And I really want all of you to be candid. I know you will. Nobody's going to get mad at anybody, but I do think it's important that we address this issue and start talking about it now. And my plan is that at our December 18th meeting to, in fact, vote on various aspects of the issues before. So let me just turn it over to the other members of the commission, and let's hear what everyone has to say. Who wants to go first? Where's Justice Tom Phillips? He usually likes to go first.
I'll say something.
I'm trying a new strategy.
Hunter.
I'm trying a new strategy this meeting, so.
Okay, well, Representative Hunter, let's start with him.
Since I'm the author of the bill, I better start off. I think, as you know, or most of you don't know, the Texas House will be doing a new transition. And so I haven't talked with our fellow House members, but I do think from the members from the House on here, this discussion is very, very good. But I think we need to at least kind of talk to our colleagues between now and your December meeting, because circumstances, are changed since when the law passed, and we'll have kind of a new setup. So I encourage the great discussion that we have with the senators and the House members, but in particular, I would like to visit with some of our House Republican and Democrat colleagues on specifics between now and the December meeting. So I appreciate you not doing a vote today, because I think we would like to get feedback from some of our colleagues, and I'm sure everybody will. And I think it's a great discussion. I think everybody's done a tremendous job, and I want to thank you, David. And let me tell you, for you to get complimented by one of the public officials, you better take it and not say anything more, because that may be the last time. So. And I'm just glad that Chip, what Chip needs to do, he's been gone so long, he needs to dress like David, because that's the South Texas way. So.
Thank you, Representative Hunter. All right.
I resemble that remark.
Yeah, David, go ahead.
I said I resemble that remark.
Any other comments? Surely someone has a comment to make. Judge Jameson.
I always will. I think it's important for us to crystallize what the problem is. The mandate we've been given has been to look at all this information. And so to that extent, we have achieved what we were supposed to have achieved when the bill was passed and the commission was populated, and with Chief Justice Phillips' fine hand editing the report that we're generating, we will have done that. But one of the people at a public meeting said, "You're trying to fix a problem that's not there." And of course, she was an elected member of the judiciary, so of course she felt like there was not a problem there, because she thought that his system had treated her just fine so far. So that being said, I think we need, you mentioned, Chairman Beck, the loss of public confidence. We've mentioned all kinds of things that indicate that are concerned that the process we have now, we have people selecting candidates who really don't know who they are. And as well-meaning as the selectors may be, they just don't have the tools available to make the best choice. If that is the problem we're trying to solve, we would go one way. If people are generally pleased with the methodology used by the governor's office, but they don't like the fact that the governor's always going to pick someone from his political party to serve as a judge, well, we would focus on that. Maybe either using the existing appointments office or creating a new nominating commission and requiring that commission to use whatever criteria, be it X number, every other judge has to be from every other party, or you have to have some sort of diversity in whatever category. So that would be a different way. But I think if we agree a little bit more, tighten up what the problem is we're trying to solve, maybe some of these options that are laid out, and I appreciate your work, Chairman Beck, for kind of reminding us of all the things that we've heard along the way. Maybe some of these would bubble up as being better. But at least as of today, we seem to know from Dr. Jones that the elimination of straight ticket voting may not have been the magic pill.
Okay, thank you, Judge Jameson. Any other comments?
I'll step in.
All right, Chief Justice Phillips.
I don't think I agree with Representative Hunter and others. We shouldn't take any votes today. But my thought would be that our initial decision has to be whether we think that some type of constitutional amendment is needed for a fundamentally new system. And if the answer is yes, then we go down that road of what it is. If it's no, then we look at whether or not there are tweaks that can be made with, and some of those can be fairly substantial without a constitutional amendment, like nonpartisan elections, or just enhancing the difficulty of getting on the ballot. There's a lot of different things that, and they're in your checklist. And even if we recommend a fundamental change that requires a constitutional amendment, I would hope that we would also have as a backup, and maybe as a more unified group on backup, some of these, some changes that might not require a fundamental reworking of our system. So I guess what I'm saying is everybody has a favorite plan, but there may be backups that we should consider recommending to the legislature as well.
I guess one comment I would make, and one of my concerns is as a frequent user of the system, and I'm going to focus on the so-called sweeps. And I'm not speaking to whether it's a Democratic sweep or Republican sweep, but really just the idea of a sweep. The problem is in the metropolitan areas such as Harris County, we're losing really good, experienced judges. And I think Chief Justice Heck pointed out that we've lost over 400 judges in the 2018 sweep. And these were judges that had hundreds of hours of judicial experience, and suddenly they're gone. But the related problem is that it's a disincentive for others to want to become a judge. Why would somebody want to leave a law firm where they are doing reasonably well from a financial and other perspective, run for office, knowing that within 4 years they're suddenly out of office again and they have to start over? So we're losing a lot of people, in my view, that otherwise would be interested in public service and serving as a judge. But it's almost like our system is a disincentive for them to want to do so, because they don't want to subject themselves and their families to the notion that even though they work hard, are ranked high by the judicial poll, and that means nothing. Their judicial performance means absolutely nothing. They're suddenly swept out because of an issue at the top of the ticket, which has nothing to do with their performance. To me, it's an inherent unfairness in the way we're currently selecting judges. That's my own view.
Well,
Yes.
Chairman Beck,
Chief Justice Jefferson had his hand up
go
first.
ahead. Go ahead, Wallace.
Okay, thank you. So the way I look at this in general terms, I agree with you, Chairman Beck, that the independence of the judiciary and the rule of law, we've got to find a way to secure those principles. But I kind of look at it as, what do I and my clients reasonably expect when you walk into a courtroom? What do you want to see on the bench? And I think it's, you want somebody who has enough experience to understand the issues, has enough integrity to not be bought or sold by a campaign contribution, and has enough reverence for the rule of law that is going to take priority in every single case that comes before that judge. And then you ask yourself, well, how do you achieve that? And so I'm talking about merit and integrity, and really sort of a sense of compassion. I know there's some controversy about that, but compassion for those who come before you. How do you achieve it? Well, that's hard in the current system because the people who are placed on the bench are not placed there based on those values. It's just not the case. It's mostly because of partisan affiliation, and I don't think that matters. I don't think partisan affiliation matters to those sorts of principles that I was just talking about. The judge you want is the one that you're going to have to convince that the rule of law it favors your client, and that if you can't convince that judge that way, then you're going to lose. And so that makes the job of the advocate that much more difficult. But it embraces our adversarial system of justice. What you don't want is to know that once you're assigned a judge, that judge is going to rule against you or for you. I mean, that shouldn't be the case, irrespective of what the precedent requires. So anyway, how do you achieve that? And I think that's our problem here, and it's a difficult one because politics are entrenched in it. I think how do you achieve it? You focus on how do you get the best quality judge that has those values that we just talked about on the bench. If it is in the current system, if we're going to do it by the current system, we don't have straight ticket voting. Well, that maybe enhances, as the doctor said a few moments ago, the value of being able to express who you are and what your experience is. And so we've had some dialogues about voter education. How do you make sure that the voter knows how many trials you've had, or how many appeals you've argued, or what your peers think of you? If there are objective measures that we can get to these voters who are no longer at least no longer have to think only about politics, but can look at qualifications, I think that would be good. And I know it's asking a lot from the voters, but that's one thing. Another is just to make the access to the ballot based on experience, both in terms of years, but also in terms of substantive cases that judicial candidate has in his or her background. And then finally, I think I think in the current climate, and this may also be just sort of my own experience, we should think about diversity as well. Gary Bledsoe testified a couple of meetings ago and talked about the new prominence of African Americans on the bench in Harris County, and how those campaigns were a lot different because they brought to the people that these judges are going to impact significantly their campaigns. It wasn't just to the law firms, it wasn't just to big businesses, it was to communities. And in a criminal case, you know, if you're a criminal defendant and you go in the courtroom and you're the only minority in that courtroom, the bench is somebody, you know, is Anglo, and the prosecution and your defense lawyer and the jury. I mean, that, you know, I think diversity does matter. And when we're looking at the issues that are confronting our nation today, I think that is something that we should think about in terms of what we recommend. So those are just, you know, I mean, a few thoughts that are occurring in my mind, and I haven't resolved how, you know, I would, you know, endeavor to fix all these issues. But I think if each one of us sits back and thinks, okay, here's the most important case in my life that I'm going to have to go to court to secure. What do you want in the judge? Yeah, you want to win, but what do you want in the? You want a fair shot at persuading the judge that the rule of law is in your favor. You don't want, and I think we should all think about, you know, not wanting to have a judge who's already predisposed, no matter what the law is, for either political reasons or because of campaign contributions or anything else. And the judges who are most qualified, in my estimation, are going to be completely unwilling to cater to that sort of agenda. And how we get there, that's going to be we're going to be debating this for the next month. But
okay.
That's it.
Well said, Chief Justice Jefferson. Let me just kind of ask a quick question. And Judge Jameson, I haven't forgotten that you had your hand raised. How do we answer the question from clients who are familiar with the fact that we elect our judges in Texas? And the first question they ask is our judge a Democrat or Republican? How do we answer that question? Because it's obvious, and really what I'm focusing on is the public perception of our system. How do we answer a client who says, okay, we're getting ready to go to court in this most important case that you know, we have as an individual or a company or whatever. Tell me if this judge is a Democrat or Republican, because at least from their perspective, that means something to them.
David, I think one of the issues that raises is the question that I get as often as that one, and that is in federal court, was it a Republican president or a Democratic president who appointed that federal judge or the judges on the panel at the Fifth Circuit? And so you know, it's a whack-a-mole game sometime, right? It seems like every time we push down, or at least I push down one problem, I see a problem with another system. And this goes back to what we've talked about so many times, and that's how difficult it is to get politics out of this. But in terms of client perception, I'm just afraid we're already too far down the road. And frankly, because of what's been happening and what's in the past, way past, depending on, you know, whoever's in the White House, how people now perceive that judges are picked regardless of whether it's federal or state, and that it's as big or bigger problem in federal court and with the appointed system.
Okay. Thanks, Lynn. Senator Birdwell, did you have a question?
Yes, Mr. Chairman. I just was going to make one brief ask or question as to process. You mentioned December 18th to vote on the issues. I think you and I had some weeks back had talked about how that vote would be done. Will there be a spreadsheet, or kind of like what we've done when I chaired Sunset? You have various recommendations, and depending upon whether a recommendation is approved or not approved, that changes your decision point for the next vote. So there's something of a critical path, like a PERT chart, that gets us to what our total resolution is. And my hope is that 3 or 4 days before the 18th, you have can give to the membership a chronological order of what the topic of the vote, because there are areas where I certainly agree that tightening the shot group on some judicial qualifications is a good thing. But I'm very hesitant, and I'll just speak bluntly, when we talk about the independence of the judiciary, when anybody ever says, you know, we want to maintain the independence, I always ask, independent from what? Independent from the consent of the governed, or independent from the bar association, or independent from? So I want to make sure that we are not removing the judicial branch from the consent of the governed. So there are going to be votes that I'll take that will very much affirm that view, but having the totality of the votes that you expect and giving each of the members an opportunity to look at the sequencing, and depending upon what may get approved or disapproved, may change votes for each of the members as you begin sequencing through those recommendations. So if it's possible to get something like that, similar to what we get in Sunset, that would be greatly appreciated. Otherwise, I think we're walking into the December 18th vote somewhat blind and not knowing the echelon of what we're going to deal with.
I think that's a fair point. I sent out yesterday what I called a menu of various issues that had been raised. It is not in what you call a chronological order. And let me take another look at that. And I'll send out something before the meeting that will kind of list the order in which we'll take them, which I think may satisfy your concern. But I think that's a very valid point. But the menu I sent out yesterday was intended to try to address that point.
Okay.
But
I want to have an opportunity as we're going into the holidays. The 18th is there'll be a few days in there. I want to be able to sit down with my team and go through that listing and be as informed as possible before the 18th.
Okay, I take your point, Senator. Thank you. All right, yes, Chip Babcock.
Thank you. I think Senator Birdwell just said something very important, and that is that we have to be mindful always of the consent of the governed. Our whole democracy is predicated on the fact that the people consent to the way they are managed in government affairs. And that to me dovetails into what I think is the problem that our justice system is facing in Texas. And that is the governed, that is the people, the public, do not have confidence in our system because our judges, they believe, are influenced by all the money that is being spent. My goodness, $4 million spent by an outside force, all in favor of Republicans, all of whom are my friends and I voted for, I'm happy to say. But that doesn't give the public a great deal of confidence in our system. When Chief Justice Jefferson says he wants to walk into a courtroom and face a judge that he and his client can have confidence in, will decide the case fairly, and they will be competent to do so. If part of the DNA of that judge is that they have gotten within the last month $4,000 from their opponent's law firm, as happened to me in Fort Worth many years ago, or somebody affiliated with the insurance industry has contributed a bunch of money, and I'm representing a plaintiff in a personal injury case. That destroys the confidence in our judiciary. It's why I've been so focused on the money aspect. And I thought it was important that we heard from a former chair of the Ethics Commission who raised the issue himself. And we have tried, in not only in Texas, but nationally, to limit the amount of money. And we have been told, properly so, I'm one of the few advocates of Citizens United, properly so, that the First Amendment doesn't allow us to restrict people's ability to talk about judicial candidates. So I think we have to get the money out of it and limit that. Senator Huffman says quite properly, well, any system we have is going to have politics in it, and that's right. And if we go to a retention system, there will be politics in that. The Iowa incidents, the situation we saw in Dallas, where Judge Ginsburg had some, made mad some very powerful lawyers, and they ran a primary opponent against him, and that primary opponent won. So, we've got to try to minimize the politics, it seems to me. I don't know that we're ever, no matter what system we have, we're ever going to be able to get it out of there. But the public perception, regardless of the reality, every judge will tell you, and I think honestly so, that they're not influenced by the money. They will tell you that. But I don't believe the public believes that. And there's massive amounts of evidence, not just anecdotal, that you, David, or Lynn, or David Oliveris, or I see in our practices. But there's massive amount of evidence that the public doesn't have confidence because of the money. So we have to address that. There is another issue of public perception that I think we have to address, and that is something that Gary Bledsoe raised, but it goes beyond what Gary said. But Gary said to us, the issues proposed by those calling for reform are mere pretexts, given the absence of a factual support for a problem and the fact that they've been in existence for years, if not decades, while white males occupied judicial positions without this same call for reform being made. We cannot be blind to the fact that in our major metropolitan areas, people of color, especially in Harris County, blacks, have been elected to the judiciary. And we cannot do something in our recommendations that overcomes that just now as people of color are starting to win these elections. For example, Representative Landgraf, I think we have to resist exempting, as some of the proposed bills have done, small counties on the theory that they know their judges. Well, the rural counties are all predominantly very, very red, as we just saw it. We will absolutely undermine our effort with a substantial number of our citizens if we don't have one approach to our entire state and we try to exempt some out. I'm almost finished with my harangue, but the last thing I think we have to resist, I've been through several sweeps. When I started practice in Dallas County, the bench was all Democratic. And then there was a sweep and it became all Republican. And the current Chief Justice of our Supreme Court was a district judge. And one is a Republican, and he called for reform, and all the Republicans said no. Now that we finally got the courthouse, we're not going to support reform. And the district judges halted that effort back in that era. Now Democrats are starting to win, and now the Democrats say no, we don't want reform because we're finally winning. Somebody has got to be an adult and step up and say no. It's not because of the party in power. It's because it's the right thing to do. And we ought to do what we think is right and resist people saying to us, well, the legislature's never going to do that. This is not possible. We should resist that. We ought to do what we think collectively is the right thing to do. And the right thing to do, in my humble opinion, is we have to change the system and we've got to get the money out of it. And however we do that, that's the proper course for us to go forward. Thank you very much.
Thank you, Chip. Judge Jameson, I think I had overlooked you, and then Senator Huffman.
Believe it or not, briefly, I just wanted to add to the concept of partisan sweeps that even once one party has all of the benches, like Harris County this time, in the Democratic primary, a lot of experienced judges were defeated, whether by a sweep or otherwise. And some of them, many of them were very qualified. And
we've lost you, Judge Jameson.
Maybe it's just as well to leave me, but am I back yet? No.
I can hear you.
I can hear.
Yeah, well, just to say, I don't want to necessarily talk about sweeps as being Republican versus Democrat, because even when one party takes control, there can be uneducated voting that happens within either a party primary or this most recent election, general election. If you looked at the, all the votes were the same, and not all of those judges are the same. All of us gonna say. So
Okay.
inform the
Senator
voters.
Thank you. I just want to follow up with my colleague, Senator Birdwell, a little bit and talk about sort of the voting that you have planned. And I'll just say this, that, you know, I was also the co-author with Representative Hunter writing this legislation. And a lot of times we have these commissions and so forth. And a lot of the value, of course, is the in-depth discussions and the study that goes on from the members of the commission, who just bring such a wealth of course, experience and knowledge, expertise to the subject, and the contribution is immeasurable. As far as, you know, when you get a final report and you report to the legislature, you know, of course, the members of the legislature are going to do what they believe is best for their constituents. They're going to go by their personal beliefs, their experience, and so forth. And so I think the value of the commission is the information that you can bring to the legislature. I will say that, of course, in my role, I have to take a lot of critical votes. I think I can speak for Senator Birdwell as well. And we take a vote on anything. It's very, very important to us that we understand exactly what we're voting for, and that we, if asked by a constituent, could clearly articulate why we voted the way we did and our reasoning for that vote. I mean, we owe that to our constituents. So I think you're going to find in some of these votes, just sort of looking at the outline and some of the things I read yesterday or last evening on your some of the topics that may be considered a topic that we have to make a decision for, you will find me abstaining, because I'm not going to commit at this point in the juncture to some of these issues. That's the way I feel about it. You know, often when I've served on several of these commissions like this, often what I'll do is sort of put an individual statement into the record about, you know, my thoughts and so forth, but not necessarily commit to the commission. I can't speak for the other members of the legislature here at all, but I think they would all agree with me that when you commit yourself to a certain position, you want to make sure you understand exactly what you're voting for. So I just point that out. This clearly is a very important topic. We've spent a lot of time on it. It's critical to Texas. I think that it's problematic because as we have all said, you are going to find objections. I think I said this in the first meeting. You're going to find objections from many Democrats about changing the system. And I know for certain there are many strong objections on the Republican side. So anytime when you find yourself in the middle like that, it's going to be very difficult to change the status quo. I think there are some incremental things that can be done. Judicial qualifications coming to mind as something that I think that we could get bipartisan support for. I'll also mention, talking about sweeps, and I was in the judiciary when the last time things were sort of changing, and that was in the 90s in Harris County. And one thing that does happen when there are sweeps, and it takes a little time, but through the primary process, the voters tend to kind of clean out those judges who are not performing as they should. At least that's what happened in prior sweeps. Will it happen this time? I don't know. But that is, the voters have paid attention and fixed that in prior times. And I know the Republicans did it in the 90s for sure. So I look forward and hope to make some differences. I just wanted to make that very clear that as we go through the voting process, that you may find me abstaining on some, not because I don't think the issues are critically important, but because I just in the context of the vote, I may not be ready to cast a vote. So that's it. Thank you very much.
Thank you, Senator. I appreciate that. Senator Birdwell, looks like you're getting ready to say something. No?
Oh, no, sir. I was,
Oh,
saw
okay.
Justice
Sorry.
Phillips' hand go up, so.
That's all right. All right. Any other comments with respect to the task before us?
Chairman Beck.
Yes.
Yes.
Chairman.
Well, you started off with the question, what can we do, if anything, to improve the judicial system? And I think it's an important question, and certainly the discourse that's happened is very germane to that question. And I think when Senator Birdwell asked a profound question based on independence of our judicial system, when he asked independent from what? Politics are inherently a part of the judicial system, and it's many ways subjective to the political arena. And I think we all have a deference to the rule of law. But the challenge is none of our views are translucent. We simply see things the way we see them from our experiences and our perspectives. So perhaps the problem is a problem of control, and that cannot be influenced by money, that cannot be influenced by campaign finance. When the electorate is changing across the state. And I think what Mr. Babcock said in regards to being concerned about being fair with whatever recommendation we give, I think that's important, that whatever is good for the goose is good for the gander. Whatever is good for the rural area is good for the more populated areas. I have served as a public official in both rural as well as heavily populated areas under Republican leadership and under Democratic leadership. And unfortunately, I think that at the end of the day, this is really an attempt to influence the judicial system in a way that is fitting to our desired outcomes. And so I think we have to be cautious. I think we have to be measurable in what we recommend. And certainly that is what politics is about. It's a game of inches that we can make improvements. And so going back to your question, what can we do, if anything, to improve the current system? I hope that we will use this opportunity to be as fair and equitable in our recommendation for all of Texas and even where Texas is headed. Those are just my remarks on that. Thank you.
Mr. Chairman.
Chief Justice Phillips.
I think many of us probably feel like Senator Huffman. You know, we might want to say a few things that nobody else would join, just for the benefit of the of any members that get to the end of the report. So my request is that December 18th meeting be more than 2 hours, because I had about 2 hours of talking in my own head, just on the basis of what's been said here this morning, but which I tried to do a good deed and not say out loud. But at any rate, I would think we would want to get we would want to know what the commission's recommendations are going to be with at least a week left for anybody who wants to prepare a separate statement to do so. And it seems to me it's going to take more than 2 hours and maybe more than one meeting for us to, I mean, as Chief Justice Jefferson said, he hadn't fully decided what his recommendation would be. And I think a lot of us are in that situation. So the debate's going to be important to us. And then seeing how all these many things on that have come up in the testimony, how we feel about them, it just seems to me it's going to take a lot of time.
Yeah, I think those are valid points. I think our December 18 meeting may actually last longer than 2 hours. I'm going to extend that a bit. I really want to try to avoid, if possible, having another meeting after December 18th because of the holidays and so on. But I do think it's important to at least have additional time available on the 18th. So I think your point, Chief Justice Phillips, is a good one.
So we should all just, if possible, reserve that entire day. I don't think it might, hopefully you'll be ruthless enough it won't last the entire day, but if it does, we should block that time out.
Yeah, there's no question the discussion is going to take some time. I think we're aided in the fact that a lot of the historical nature of our report is already done for the most part. As we circulated earlier, we've got a 36-page draft of a report that was circulated again this week, previous drafts at earlier meetings. So as I mentioned before, if anybody has any changes in these 36 pages, please forward those to Chief Justice Phillips, who's kind of our historian, to make sure that everybody's comfortable with that. And then we'll add to that whatever recommendations the commission is willing to agree upon. And I will say, Senator Hoffman, I never in my wildest dreams thought that our recommendations would be unanimous. So I knew that there would be people with differing minds, which is fine. Reasonable minds can differ, as we all know. But I'm hopeful that on the 18th, we all come with the state of mind that we really want to try to do what is best for the people of Texas. I mean, these are the ones that use our system. These are the ones that Senator Birdwell keeps reminding us really are the people that we should pay homage to. But on the other hand, we've got to come up with a system that the people believe in and know that justice will be meted out on a basis that embraces integrity. And as I said earlier, whenever a client tells me or asks me, is our judge a Democrat or Republican? It always troubles me because that tells me what their mindset is. And I always try to explain to them, who the judge is. And I say, it's not going to matter. We're going to get a fair trial and so on and so forth. And I hope I'm right. But I don't really know that in some instances. So any other issues or comments anyone would like to make before we adjourn? Hearing no further comments, thank all of you very, very much for your attention. The discussion, I think it's been very helpful. And let's all be prepared on the 18th to address these issues and finalize our recommendations to the legislature. And then they can take it from there. Thank you all very much.
Thank you, Mr. Chair.
Thank you, Chairman.
Thank you.